Hi everyone, this is Pennsylvania attorney Evan Gutman, here to present video number 6 of my legal video education series that addresses the process of becoming an attorney and the licensing process, and particularly the good moral requirement. The video series is based upon my book that I wrote titled State Bar Admissions and the Bootlegger's Son. The full book is available on either of my two websites, both of my two websites, heavensadmissions.com or gutmanvaluations.com. Those websites also contain a supplement that I wrote to the book several years later, as well as a fictional novel I wrote titled Heaven's Admissions Process that humorously and somewhat interestingly compares the process of becoming admitted into heaven with the criteria for becoming a licensed attorney as regards the good moral character requirements. So it's a fun book, actually. Fun novel, I should say. So here we go with video number 6. And just so you know also, you should have access to a PDF that provides the written material related to today's presentation. It's available on Facebook as well as on both of my websites. So you should be able to have a link to see the PDF. And if you don't see the link, you can just go to the websites and you can find the PDF there. So video number 6, I'm going to present the history of the attorney licensing process in the United States. Virtually every profession other than attorneys, the individuals or the professionals are licensed, whether it's medicine, accounting, engineering. The individuals are licensed by a state agency that is typically established by the state legislature or executive branch of government. The only profession in today's world that I know of that is licensed by the judiciary branch of government is that of attorneys. The judiciary does not license professionals in other branches. The only profession that they license individuals is in the legal profession. That was not always the case. In fact, it didn't really become the case until the last 100 years. Prior to the last 100 years, attorneys were regularly licensed by agencies either within the state legislature or the executive branch of government. As a point of fact, prior to the early 1930s, the process of becoming a licensed attorney was quite haphazard at best. Throughout the period of the enactment of the Constitution from 1789, all the way up until about the early 1930s. So I'm going to talk a little bit about the licensing process and what's happened to it. In early revolutionary times, when we were going through the Revolutionary War in the late 1700s, the process of becoming a licensed attorney was quite different, to state the matter mildly, than today. For instance, to give you some examples, American patriot and Revolutionary War hero Patrick Henry, who was an attorney. His primary source of, quote, law school training consisted of listening attentively to conversations of members of the bar at Shelton's Tavern. That was his legal education, going to the tavern, drinking with everybody and listening to conversations. Purportedly, he set off to take the bar exam, which was an oral exam at that time. It wasn't even a written exam. And he took it from a man called George Wythe, who later became actually Thomas Jefferson's tutor also. After Wythe signed the paper based upon the oral examination for Patrick Henry then went to see John Randolph, a prominent Revolutionary War hero. And John Randolph, upon learning that Wythe had signed the authorization, John Randolph then also signed it. Thomas Jefferson became a law student at the age of 19, who also studied under Wythe, George Wythe, and his route to become an attorney was similar. Perhaps the most famous U.S. Supreme Court justice of all, John Marshall. enrolled in William and Mary Law School on May 1st, 1780, and a few months later had his law license. So the concept of a law school, excuse me, the concept of a law school really didn't exist hardly at all, if it existed at all itself. It does not take a genius to recognize that in order to get a law license at that time, the real key was not what you knew, it was who you knew. If you knew the right people, they would just sign off on it and you'd be an attorney as long as you behaved and conducted yourself with respect to the way they wanted you to behave. And that is what the legal profession, although it's changed markedly since then, that's what it's really always wanted to preserve. That's how the judges really want it to be. They want it to be based upon who you know, not really objective standards upon what you know or what you've done. They really want it to be based upon whether you're friends with the right people. That's how the legal profession started out, and that's how they really want to keep it. What then happened is that the rise of Jacksonian democracy in the 1800s, the first part of the 19th century, eliminated the few educational requirements that even existed to become a lawyer. As late as 1900, very few states even required a law degree for admission to the bar. Today, it's a given that you pretty much need a law degree to be admitted to the bar. Although there are actually, I think California may have an exception on that. But for the most part, as late as 1900, few states even required a law degree to be admitted to the bar. Between 1880 and 1920, with the rise of the ABA, which was established in 1878, things started tightening up markedly. States started adopting admission requirements to become a licensed attorney, which included the publication of applicant names so that other attorneys could comment upon them, whether they were the type of people that were really wanted or not. Probationary admissions, where you're kind of an attorney but not really an attorney. You're admitted, but we got to see how you do, and then maybe we'll finalize it. Investigation by character committees, which is certainly a main topic of this book. By 1917, 3/4 of the states had centralized authority in boards of bar examiners. And the ABA was spearheading a campaign for higher professional standards so that they could ensure a subjective rather than objective assessment was made, so that they could admit the individuals that they really wanted, but exclude the individuals that they didn't want. Typically, candidates denied admission at this time in the 1920s on the disingenuous ground that they lacked moral character or were, quote, unworthy or morally weak. Typically, those individuals denied admission were immigrants, Jewish, black, or women. Those are the people they wanted to keep out of the legal profession. Cases up until then had established that the power to license attorneys shouldn't vest in the judiciary at all, that it should vest in the legislature. And that's what the ABA really wanted to get, and that's why they started the National Conference of Bar Examiners in the early 1930s. But in 1860, New York, in the leading case, in the case of In re Cooper, the state of New York held that the licensing power belonged with the legislature, not the judiciary. In 1864, California made a similar determination that the licensing power should vest for attorneys with the legislature, not the judiciary, in the case of Ex parte Yale. In 1906, North Carolina made a similar determination that the power to license attorneys should vest in the legislature, not the judiciary. So you had leading cases throughout the entire nation that were forming the basis for licensing attorneys by state legislative agencies instead of judicial agencies. Once the ABA mobilized, once the NCBE came a force, a political force, and that is what it is, that changed. By the early 1930s, pretty much a number of states, a lot of them had now held that the power to license attorneys vested with the judiciary, not the legislatures. Arizona did so in 1932 in the case of In re Bailey. Wisconsin did so in 1932 in the case of State v. Cannon. South Dakota did so in 1909, actually, in the case of Danforth versus Egan. Illinois did so in the case of People ex rel. Illinois State Bar Association in 1931. So in the same manner that the judiciary had seized the power to interpret the law in the seminal case of Marbury versus Madison in 1803, approximately 125, 130 years later, by the 1920s and 1930s, they similarly and quite questionably seized the power to license the attorneys from numerous state legislatures that had held otherwise in cases that asserted the licensing power belonged with the legislators. And they did so, they seized it for the benefit of the judiciary in cases that the judiciary itself decided, just like had occurred in the case of Marbury versus Madison. It really is troublesome and problematic, the subjective way they assess moral character. In the late 1920s, 1930s, the state of Pennsylvania, which is where I'm now a licensed attorney, I'm a licensed Pennsylvania attorney. The state of Pennsylvania, which played a key role actually in the development of the licensing process for attorneys in the 1930s, at that time, their definition of individuals who were unworthy was also quite elastic. They rejected individuals on the basis that they were dull. They rejected individuals on the basis that they were shifty, that they were arrogant, conceited, slovenly. A substantial number of individuals were denied admission on the grounds that they lacked a, quote, proper sense of right and wrong, unquote. These are very ambiguous adjectives that, if not backed up by objective conduct indicating such, do not warrant denial of admission. In my book, State Bar Admissions in the Bootlegger's Son, I demonstrate by analysis of many, many cases in virtually all of the states that are contemporary. I say contemporary, they're generally from around 1980s, 1990s, the year 2000, basically early 2000s. Basically, I demonstrate that exactly the way they were doing it in the 1930s is pretty much how they're still trying to do it today. And the reason is because my main objection is that licensed attorneys should be required to answer the same questions of bar applicant non-attorneys on a regular and periodic basis. Because once everybody's got to answer the questions on a regular basis, the questions will start becoming more fair. Until then, basically, we can figure that there's going to be a lot of unfair, ambiguous, unconstitutional questions that will allow state bar committees to deny law licenses based upon whether they just like or dislike the individual. So that concludes today's video on the attorney licensing process. The next video will be in the next day, 2 or so, roughly. Hope you enjoyed it, and remember, love right, don't fight. Bye.